Let's talk money.
Hello and welcome to Let's Talk Money. I'm your host, Surabhi Upadhyay. India has finally ushered in a new era of labour regulation, a long pending reform that is aimed at improving worker welfare and boosting the ease of doing business in the country. On the show today, we will understand how exactly these 4 new labour codes impact us, corporate employees, what happens to our salary structures, what happens to our take-home pay, and do our retirement benefits actually improve? Well, joining me to shed light on this very important subject are Sonu Iyer from EY India and Vaibhav Bhardwaj of Khaitan and Co. Ladies and gentlemen, thank you so much for joining in. You know, last couple of days, so much has been said about what happens, and there's been a lot of talk of whether we get our gratuity early or not, and whether PF goes up, but our take-home salary comes down. So plenty of excitement for obvious reasons. So thank you for joining in for this. And I want to start by getting your opening thoughts, because this indeed is a landmark reform. And these codes were actually, I think, set up in way back in 2019 or 2020, if I'm correct. Sonu, so let's open with you. Your first thoughts.
Thanks, Surabhi, for having me on the show. So as you rightly said, long time coming. We've ushered in an era of new labor laws, which was really needed. I'd say in one word, these are game changers. It is the beginning of the new era of labor laws, which was much needed to modernize our workplace in sync with the modern workforce, as also making much more stability, uniformity. I mean, the whole idea of 29 fragmented laws coming together, being compressed into 4 labor codes. Simplification is the game. Universal wage, trying to bring in social security for the informal sector, gig workers, platform workers, which is the modern workforce. So, game changer for women, allowing them to work for night shifts with their consent and ensuring safety and ensuring that security is there, transport is arranged. So, and gender neutral policies, equality in recruitment at the time of salary fixation, retention. So that gender neutralization is a great thing and really, really sets the way to get to a $10 trillion economy that we want to become.
And change in our labor laws has been one of the long-standing demands from India Inc. as well. I'm sure you'll agree. So what do you think? I mean, now that we have these 4 new codes, are they more industry-friendly or are they more employee-friendly, or do they manage that fine balance?
No, I think it will be able to. It's a balanced reform, and honestly speaking, it's a very welcome change and a welcome reform. Because if you look at our legislation, some legislations even date back to our independence era. So, and of course, given the fact that over a period of time, the businesses have changed, the business model have changed, but unfortunately, the dated legislations never thought through about these legislations. And that was one of the reasons why there were several legislations, specifically as far as labor is concerned. And with these changes coming in, of course, there will be uniformity. But still, there is a long way to go. It's a long journey because implementation is the key aspect. As Sonu has also pointed out, there has been a lot of welcome changes, specifically with respect to recognition of gig workers, gig economy, because gig economy has grown exponentially in last 6 to 7 years. And the biggest issue was that the gig workers were never protected. There were no laws regarding gig workers, and now with labor codes coming in, there have been something in place wherein, yes, there are safeguards in place. They will be subject to certain benefits. There will be health insurances and so far. So far, it's a welcome change, but the biggest challenge is on the implementation part.
Yeah, and we need to see if all the supporting legislation, how quickly it gets underway, when are the final rules notified, actual rules and the details that will operationalize these codes. And there are 4 codes, by the way. So let's just have that graphic up on your screen. And a lot of these changes that we're speaking of, whether it's women working at night, whether it is the definition of wages itself, all of them come under one of these 4 codes. So the first one is the Code on Wages 2019. Then there is a Code on Social Security 2020, the Industrial Relations Code, the Occupational Safety, Health and Working Conditions Code, which among other things, by the way, one of these codes, I think is the last one, which mandates health checkups for employees who are over 40 years of age. So lots of new things coming in and generally lots of good things for employees. But Sonu and Vaibhav, I want to start right there. The definition of employee and the definition of worker, right? Just tell us from our perspective, and a lot of people who watch this show they are working with the corporate sector or maybe even with the public sector, but they end up being salaried employees. So do we need to go into this nuance of employee, worker? Is there anything new that we should be aware of? Sonu?
So, definitely we need to focus on this change. Definition of worker is same as the definition of workman under Industrial Disputes Act. Why this becomes critical is the worker being defined across all codes uniformly is to say that anyone who's not in a managerial or supervisory role is likely to be treated as a worker. If someone is not in a managerial or supervisory role, will become a worker, and therefore job descriptions, roles and responsibilities all need to be well defined to ensure who's an employee, who's a worker. Because workers have additional benefits, they are entitled to overtime. They get additional compensation on being asked to leave. So there are benefits that are attached to workers, which we need to be mindful of.
This is important. Vaibhav, come in on this, because even in corporate organizations, I mean, if I'm not a team leader, if I'm a team member, and therefore I don't have any managerial responsibility, then do these new laws mean that I'm a worker? In which case, like Sonu is saying, then, overtime pay, a lot of other benefits come into the picture. So what's the interpretation?
Case as well, because worker is equivalent to a workman under the Industrial Disputes Act, which was the erstwhile legislation. So yes, on-ground role and responsibility, and actually what the employee is performing on ground is the key factor to assess whether a person is a workman or not, or worker in the present case. And now if you look at employee versus worker, employee is a larger definition, or it's an umbrella definition under which a worker would fall. So yes, there are certain legislations and there are certain provisions which will only be applicable to worker, and such as retrenchment compensation, which was earlier in the Industrial Disputes Act and now it's in Industrial Relations Act. So that will still extend, but that would only be for worker. So there has been no change from that perspective. Yes, but they have aligned the definition with what was in the erstwhile legislation.
And what about overtime benefits? I'm sure that's a phrase that caught everyone's attention. But does anything change? And I'm talking about, again, this question pertains to salaried employees who do not have managerial roles, who are in execution roles. So what about provisions of overtime?
So I'd say that workers are entitled to overtime, and overtime is 200% of your wages. So it is not everybody who gets overtime, it is. But I think the other good thing that has happened is rationalization of working hours. So the overall governance around 48 hours in a week has been maintained, but there's much more flexibility for the employer to be able to set working hours according to that. But a lot of work needs to happen for harmonization of all of this, because state governments will come out with their own specific rules. There are already Shops and Establishment Act which have working hour conditions, etc. But work, as we spoke about earlier, the good thing is that the framework has been given, but a lot more needs to happen from a detailed perspective in operationalizing all of this. But yes, the codes say that working hours will be capped at 48 hours in a week, 125 hours in a quarter, which is towards rationalization and ensuring there is much more governance around working hours.
Okay, all right. So that's something that we're going to watch out for, all the final rules as they are operationalized. Now we come to the crux of this, the definition of wages and the 50% cap, which has been now imposed through these labor codes when it comes to exclusion. So we need to start understanding our salary structure very carefully. So Sonu, if you could just illustrate this, because anyone's total cost to company has a lot of components. There's a basic, there could be an HRA, there could be a special allowance, etc., transport. Will salary structures need to change because of the new codes?
Okay, I'll answer this in a way. Right now, in our sort of the outgoing labor law framework, definition of what should be considered as a basis for calculating benefits was different for different things. You had a different way to compute gratuity, you had a different way to compute leave encashment or other retrenchment compensation, etc. So the reform is to have a consistent definition of wages across all such retirement benefits and payments, so that we have consistency and nobody uses different this thing. Now, in a salary structure, what they're saying is that the employers will also have to look at it from a perspective of workers' right being protected, that exclusions that can be excluded from the definition of wages to compute benefits will be capped at 50%. So like we have exclusions like house rent allowance, conveyance allowance, statutory bonus. All of these are excluded from the definition of wages for computing, gratuity, etc., as per the new law. But the cap is at 50% of these exclusions are permitted only.
Sonu, let's take an example. Your numbers always help illustrate this point. If we can actually just break this down, like I said, someone will always have different components to that salary structure. So how will this 50% cap be calculated, and what could be the change in the wage itself? If you could give us one or two examples.
Okay, so if you would want me to look at an example, I then have to look at my notes. So base salary, say if I have basic salary of 20,000 and I have a house rent allowance of 10,000 and a conveyance allowance of 8,000 and a special allowance of 12,000, which adds up to 50,000, right? Now, if I were to say that my total salary is 50,000, let's look at it as per the definition. And right now on example one, what can be excluded from the definition of wages? House rent allowance can be excluded, conveyance allowance can be excluded. So my exclusions are 18,000 rupees. What is 50% of 50,000, which is the comp salary? That is 25,000. As per law, I will be able to exclude from the definition of wages whatever is the amount of exclusion or 50% of salary, whichever is lower. So in this example, it's 18,000, which is excluded. For the remaining, you have to pay, compute gratuity and benefits on that definition, which is basic and allowance, right? Earlier, many of these allowance benefits were computed only on the basic salary. So to that extent, there is a cost increase that is happening for the employer. You look at the second example, which is where, which is more telling, where it brings out what is really the change. When I'm talking about the fact that, if my basic salary is 20,000, the house rent allowance is 14,000, conveyance allowance is another 14,000, and special allowance is only 2,000. Now, if I add up the exclusions, which is HRA and conveyance allowance, that adds up to 28,000 in this example. Now, if that is the case, if you remember the 50% of the total remuneration, 50,000, which is only 25,000 rupees. So when I compare 28,000, which is my exclusions as per the structure, with the 50% of the total remuneration, I will be capped at 25,000 only. So irrespective that my, HRA and conveyance allowance are adding up to more than 50% of CTC, but as per the new definition, my exclusions will be capped at 50% and rest will be added back to basic salary and allowances to compute the benefits.
So essentially, in cases where the exclusions have been very high and the basic salary has been low, that's where there's likely to be a change. And some of those high exclusions will be plowed back from the exclusions bucket into the wages bucket. So the actual wage ends up being higher. It cannot be lower than 50% of total compensation. Got that point? We need to take a break, but we'll dive a little deeper into this, and we need to understand then what this change in the definition of wage, what does it mean for our benefits? We'll discuss that after the break.
Let's talk money.
Welcome back. You're with us on Let's Talk Money, and this week we are discussing the all-important brand new 4 labor codes that have ushered in a new era of labor reform in the country. Now, we've just understood how the definition of wages itself is changing. And let me go back to our guests. Of course, Sonu Iyer of EY with us and Vaibhav Bhardwaj of Khaitan and Co. also with us. Vaibhav, this question to you, because Sonu just explained to us how the definition of wage will change and the calculation could change if your employer has been giving you too many exclusions as part of your CTC. But the other worry is that with a higher definition of wages, what happens to my provident fund? The worry is that I'll be, a lot of my salary will go into PF. I won't have enough to spend right here, right now. Is that the way the law is being worded?
Yes, from a long-term perspective, there are huge benefits. But just to explain to you, the definition of wage, I would say it's one of the instrumental change under the wage code. And just to take a step back, there have been judicial precedents, and it's a settled position of law that the allowances that are universally payable to everyone should be included as part of basic wages while calculating provident fund. Now, this is something which is a settled position of law, and in fact, the Supreme Court has also recognized this particular matter. Now, with the wage definition, it has become extremely clear that what allowances can be included. And if the allowances are over 50%, then the remaining portion or the extra portion need to be included as part of basic wage for the purpose of calculating all retirement benefits, because now it's a uniform definition. So whether it's PF, whether it's gratuity, whether it's ESI, everything has to be calculated basis the definition of wages. So of course, the impact is twofold. The employer contribution would also increase. So there will be an increase in the financial burden of the employer. And from an employee perspective, their take home salary would reduce. But ultimately, the employees would be better off from a retirement perspective, because their corpus will be accumulated at the time of the retirement.
I am sure this debate is not going to end anytime soon, but Sonu, weigh in on this. And also the original definition of the calculation of PF, right? It used to be that 12% of basic, and then I contribute that much, and the employer contributes that much. And that's how you get a nice little PF kitty. But now it's not necessarily the pure term, the basic pay, right? Because like you explained to us, that if you have any retainership allowance, the DA, all of that is wages. So will PF be paid on this wages, which could be a bigger number itself? Is it still 12%? Will the employer still contribute as much? I mean, just tell us what we can expect on the PF front.
Okay, so maybe just add in on what Vaibhav said. First of all, the fact that, the government has been, working on a larger stated objective of social security for all, and ensuring that as, longevity of lives is there is a retirement kitty. So Provident Fund towards is that one major benefit that employed workforce and now the informal workforce through social security, we are aiming to create a retirement kitty. Keeping that objective in mind, the government wants to be able to make sure that there is a resizable corpus available to employees once they retire. What is changing right now in labor codes, there is, of course, the new definition of wages, which will be used across Code on Social Security 2020. But on Provident Fund, I think there's a lot more that needs to come in, because what the code says is that it will be 1 year from the date of notification of Code on Social Security 2020 that we will see a new scheme of Provident Fund come in. As things stand today, whilst we have a definition of wages which is applicable, but because in the existing Provident Fund scheme itself, we have 30,000, 15,000 rupees is a salary for reference for calculation of Provident Fund, which will continue until the new scheme is notified. So in the short run, I do not expect any changes on the take-home salary because of anything going up, because this is still something that is work in progress. The rules will be notified, the schemes will be notified for Provident Fund. So we expect to see final word coming only once the scheme is notified. So there should get impact, but in the long run, it is a reform that is intended to bring in greater financial security and a larger corpus of retirement fund available to employees. So it's a positive change, and because there is rationalization of definition of wages, it ensures that anyone who is working is able to create a sizable kitty for themselves towards retirement.
Vaibhav, just come in on this, this whole PF calculation. Now, like Sonu mentioned, that the actual cap, the mandatory sort of threshold for corporates is only, I think, 15,000. They have to pay PF on a 15,000 salary. Over and above is, depending on your salary structures. Just explain how this could play out, because in most cases, even the employer's contribution to PF ends up being part of your CTC. So is it really going to be hitting the corporates? Will it really add to the wage bill at all? And once again, on PF, what would your 2 points be right now? I think you're mute.
Sorry. So as Sonu also pointed out, it will be interesting to see how the PF schemes comes through. But yes, as of now, of course, the employer contribution is only capped at 15,000, and more than 15,000 and some employer wants to contribute. It's as per the discretion of the employer. But yes, purely from a PF perspective, I would say in the long run, the take-home salary would reduce, because the PF contribution would increase because of the change in the definition of wage, and a lot of allowances will be included as part of basic wages.
Okay, all right, got that. Which brings us to another important subject, and that's gratuity. Now, good news if you're a contractual employee, because I think here, Sonu, now instead of waiting 5 years and then finally getting gratuity, even if you've worked on contract with a firm for 1 year, even then you're entitled for gratuity. Is that right?
Okay, let me sum up the changes in gratuity because there are all kinds of interpretations in gratuity. As we understand it, the two changes which are relevant from a gratuity perspective is in case of fixed term employment contracts where you have a contract for a fixed term of employment, gratuity will become payable after 1 year of employment. So gratuity comes in for fixed term employee which was not there earlier. So it's a very positive benefit. There is also, of course, parity in all kinds of benefits for fixed term employees as is available for permanent employees. Now, in case of permanent employees, the eligibility for gratuity only kicks in after 5 years of working. And what is changing there is that the calculation of gratuity will be on the new definition of wages. Up until now, gratuity was computed only on basic salary and dearness allowance, if any. But now it will be on the new definition of wages, which we just discussed, which is basic salary plus allowances, exclusions being capped at 50% of the remuneration. So that's the change on gratuity. Again, currently the gratuity ceiling is also capped at 20 lakh rupees, but there will be a new notification that will need to be issued under the newly notified Code on Social Security 2020. So we'll see if the gratuity ceiling goes up, but the current 20 lakh ceiling continues as was the case under Payment of Gratuity Act.
So sounds good. I think the sum and substance of this is that this is a good reform. It's good for employees and perhaps not too bad for employers either. So win-win in that sense, perhaps, truly speaking. Thank you so much, Sonu and Vaibhav, for joining in and making sense of these all-important labor codes for us. And thank you, viewers, for watching. If you still have any more questions, please keep writing into us and we'll make sure that they are answered in the coming shows. See you next week with another theme.
Let's talk money.